The- I am in possession over the suit land on the basis of lease from the Hubli Temple Administrative
That
Authority.
is what is there. We are not concerned whether there is any authority given to you to occupy it. If it is a proper authority given to you to occupy, you remain there. We are simply concerned, showed our concerns on the encroachment having made to the land belonging to Lord Jagannath. That's the only concern. So your concern, your presence is not actually required. If you are not an encroacher, no fair, no difficulty. If you are an encroacher, they have to take steps in accordance with law after giving you a notice or whatever.
As per this PIL, the Tahsildar has issued an eviction notice to the citizen.
So that will be, it's a law. If you say that I have a protected right, you just go and appear before the Tahsildar. Go and appear before the Tahsildar. Why? We will decide it here. You're right.
Claiming the right over the suit land. My humble submission before a lordships that the total area is 10 decimals.
So can we go into a PIL like this? We will be deciding your personal right. Whether you are occupying outside the Jagannath temple's premises or land or within the Jagannath temple's land, it is the Tahsildar who will decide. What we will do, we are simply concerned with the protection of the property belonging to Lord Jagannath. That's all. If the law protects you, you are there protected. If it does not, then you can't.
Apart from that, my lord, I have filed a suit.
Go there.
No, my lord, there is a status quo order
Go there.
in respect of this property.
No difficulty. Enjoy that. We are not going to say, we'll say in accordance with law.
In accordance with law.
That's all. We do not want anything more.
With the lordships.
We will not. You are simply intervening will not do. Yes.
The eviction notice, the opposite party had come to this honorable court and they had seek the order from this honorable court.
Maybe.
Something is passed appeal order.
Whatever. We are not concerned. When you have come with the PIL flagging an issue that there has been a lot of encroachment on the land belonging to Lord Jagannath, we will definitely direct them to take steps in accordance with law. Whatever, we are not going to see that. Brother, we can't unnecessarily these. That will take care. They can't violate.
That is what he has brought to notice of this court.
That is his presence is
You are
not.
opposite party. You are representing opposite parties.
No, ma'am. No,
Yes.
I am not representing the.
No, he's an intervener. He has filed an application to intervene. The present this petition in the nature of a public interest litigation encroacher. You have to be dealt with. I'm surprised that you are protected with any interim order.
By the
My lord, I am appearing through VC, my lord. So I am for the OP7, my lord. The temple administration, my lord.
Item number 3.
Yes,
So my appearance may be noted.
yes, definitely.
My lord, much obliged.
My lord, in this matter, we paid for some time to open.
You prayed for time in the month of August, now again prayed time for in the month of October. How much time you require?
We had only 3 days time because we had, in the meantime, I have obtained instruction, we had.
In the meantime, and I do not know, 18th August was the last day.
Because we had, this instruction, we had, I need to discuss with the officer. It's not properly what is that.
That shows that the authorities are not sensitive enough
And it only.
to give you an instruction. You asked for 6 weeks time on 18th of August. And we fixed this matter on 13th of October to give you a good enough time. And till today, even still, you have not received.
We had only 2 days.
If you cannot get it within 6 weeks, are you sure that you will get it within 1 day or a 2 day? 2 days.
It is. Not prior to that. The instructions, when has it come?
Yes, you want to see the instruction.
No, yes.
It's likely to receive the
I have got the instruction, we had, but, yesterday.
Days before you have.
Yes, yesterday. Only 4 days time. It is from Kotak.
Briefs. Once it is introspect for you, then you have to take charge of that case. And it is not that the previous day it comes to whosoever additional government administrate is entrusted with 1 to 20, 11 to 20. Then when you come across with possibility of
Item 4. Item 4.
Lordships, where a lead application was filed, which was withdrawn with liberty to file new by way of public interest litigation. And lead application has been filed by the villagers, the petitioners are the villagers of the remove the details.
There was a debate which was shown by the deputy registrar on Friday. What are the debates now? We remove it's removed and it is number. It is removed. Yes. So why just go to the order of highway, that's why that's the I.
Your lordships, the present petitioners are the villagers of Noarenta. Belonging to block
For the foundation of Sarkari Unnita Uच्च Vidyagar Renta. This was. Yes, so this Sarkari Unnita
उच्च विद्यालय under 50 योजना
No. The immediate state for function of, I did not know. What does it mean? So the function of him. Not functional.
Yes, so lots of the school building has been constructed by 2021, but it is not functional.
What?
The opposite parties are not taking steps.
So no, this is the government school or the semi-government school?
Government school, under government 50 Yojana, the government school was constructed in village Srenta. But the school is not functioning.
Near
Represented
structure with the cement and mortar will not do. They have to. And this is your obligation. You said under the directive principles, but your obligation, what so?
I'll take instruction in this week.
It is that it is.
It's a government school. He's saying it is a government school. Has been funded under the 50.
How many students are there in the,
more than 77 students
where they are studying?
They're studying in another school, which is 5 kilometers out. It is situated at Mahasindhu village. And that school and the students have to travel more than 5 kilometers. And
But here after construction of the school, this school has never been made functional. That is the allegation.
That's true.
So far as those students he is referring to, those students are already studying in a different.
He's not saying that they are not studying. How can? They can't remain. As what he's saying is that they have to
Travel.
undertake a journey of 5 kilometers. And realizing that these are the problems which the students of the village are facing, you have set up this school here. And will you not make it functional?
I'll take-
Come on, 27, take a step,
27.
otherwise we will have to.
your lordship, and your lordship representation.
What is 37? Page 37. What is this, letter?
Represented.
No, 37.
Oh, there is already a school. Renta UGHS Mahasindhu.
And that is 5 kilometers away from the building that is constructed.
No, it is not a shifting. It is the new school that has come. If somebody wants to study here, they will study here.
But the school is not functioning because teachers are not being appointed.
Page 37, my brother, remember, you have sought for a shifting. If the government says it's not possible.
But the government has constructed the school. By
Why
spending
you
huge amount of money.
why you do not make it
I'll
operationalized?
take it.
Just respect brief also.
What?
What will be made by the additional district education officer is Dover.
All right.
Has leadership to be collected.
That repetition, if your lordship will find at page 45, that has been withdrawn. That earlier a PIL was filed and that was withdrawn with a liberty, but that was filed by one Vishwanath Pradhan. Here, another set of petitioners, they have filed the present.
Whatever, forget about that. We want-
I'll take instruction on that. I'll take instruction.
Item 5.
This is the second time journey of the present petition.
This is the order of 11/8, 2023. Mention two.
Honorable Honored Collector of Bhadrak is passed the order. My lord, page 19, para 7. In view of the aforementioned facts, having heard to the petitioner's sides and after going through the document annexed to this case record, this court is of the considered view that no coercive action will be taken.
Where is the order of the High Court?
Here, this honorable court, Annex 1, page 16.
That's simply set an examination,
Mine.
nothing more than that.
But after this order, Honorable High Court,
Yes.
The learned collector opinion number 5 passed an order para 7 page number 19.
Yes.
The in order para 7, my lord, I read. However, the no additional construction shall be made on the plot which has been recorded in the name of the Jitanam Upper Primary School. BDO Bhadrag will identify suitable land in nearby school premises for the purpose of playground in consultation with DO Bhadrag and SMC member. Sarpanch Kedarpur GP will also ensure conductive study atmosphere during the school hours, and there shall be no hindrance for the student due to functioning of
What is
the
the school?
well,
What is the school?
school is upper primary school. Jitanam Upper Primary School.
That's a government run school or
Minor government.
government?
Here is the case is Gram Panchayat and of private.
They say.
But
Consumed other on answer 8. Arranges out of an order dated 22nd 2022. As in an earlier date petition, wherein the petitioner has prayed for the extension of time.
Oh, that is separate writ petition. You could have come in that writ petition itself.
No.
For extension.
The earlier petition, the petitioner has filed for extension of lease period for 1 year. Since he was obstructed by the physical obstruction of the inhabitants of that village and also filing of PL and pendency of PL, the sand quarry was not operated for 1 year. Therefore, he has paid for a direction in the earlier petition, and in that petition, this honorable court directed to consider the application of the petition.
They have rejected it. Says
They have-
that it
they have
does not
rejected-
come within the purview of Rule 8(4) of the OMNC rule.
Yes, ma'am.
So,
But the-
show us that it comes within the purview of Rule 8(4) of the OMNC. Show us. Doctor. Orissa Minor and Minerals Construction Rule, 2016.
Rule 8(4).
Yes.
The maximum period
Look at
for
that. You just show me. That Rule 8(4) says.
the maximum period for which a quarry lease may be granted shall not exceed 10 years and shall be subject to such terms and conditions as may be specified by the concerned authority, provided that the minimum period for which any such lease may be granted shall be of 5 years. So my lease.
You have exceeded 10 years.
No, madam. Since I have executed the deed for 5 years, and from that 5 years, 1 year has been obstructed by the villagers and pendency of PI. I have given all the royalties for the entire 5 years period. Exactly in a similar case, I mean, draw your lordship's kind attention. If the order of this honorable court.
This is a specified minor mineral or what?
It's sand minutes.
Time does
Does
it
not
come
come
within
under.
the specified?
No, my lords. No, my lords. Section,
Then how 8(4) applies?
it does not apply, my lords.
So how your authority has taken
My
care?
lords, they have mentioned.
Oh, acha, query does not come.
Yes, my
Sorry.
lords.
Okay.
Yes, my lords.
And the sand comes under what?
My lords, if I may refer to Rule 3AA, specified minor minerals,
No, I understand.
Yes,
That's why I asked you this question.
and Schedule 3, my lords. Sand is excluded, my lords.
Yes, I perceived so, that's why I asked.
Yes, my lords. Sand is excluded, my lords. And
So
what?
there is no provision for extension.
No, there is no
There is no
provision of
provision.
extension under the rules as well as in the lease, there is no provision for extension. And the application for extension was filed after the expiry of the lease deed. And my lords, there is one judgment of this honorable court, similar facts, my lords, saying the same thing, my lords. If I may refer to those, one judgment, my lords.
I have also given all judgment of this honorable court.
Now there is a conflicting judgment, so what to do, let us see.
We'll also turn to paragraph 5.
Case 3, paragraph 5. Having heard on counsel for the party, this court is of the view that mere absence of specific provision in OMC rules 2016 should not come in the way of petitioner getting an extension of.
No, that is the difference. There was a judicial order of.
Yes, Your Honor. But in the my case,
This
Your Honor,
is the obstruction was created by the villagers.
Yes.
Have you intimated that?
Yes.
to the authority?
authority-
Have you asked for?
I have intimated the authority have made a joint verification. In joint verification, it was found. And joint verification was made in view of the direction given in that PIL. The PIL with the inhabitants of that village, their villagers are fine. And in view of that direction, they.
Was there any interim order passed in the PIL?
No, there is no interim order.
So there was no prevention, there was no prohibition on your part to continue with the query.
Since the villagers prohibited me and I have
It
intimated,
cannot be, you could have filed an FIR, you could have proceeded on
I
that
have-
basis.
I have taken all the steps. Your Honor, kindly say,
Where is the-
Your Honor, kindly say Annex 3. Annex 3.
Once that you have.
Next
That's
to three.
the inquiry report.
Annex 3, the inquiry report and the inquiry report. And prior to that, Annex 2 also, Your Honor, kindly see. Annex 2, the steps which I have taken and according to the authorities have taken the steps and prayed for the deployment of police to demarcate the land. Annex 2, deployment of sufficient police force for controlling of law and order situation at Ambo, Korogola, Sankori during demarcation. And page 44, that is.
So that was in your favor.
Yes, Your Lordship.
So
The
what?
the authorities have sought for police force since there was serious obstruction by the inhabitants of that area.
When the these was executed,
Executed for 17.
17. So. And this was of 2020. You would have continued. And there is no prohibition. which you have said.
5/4/2017 lead were executed.
Did you approach the police authority by complaint against that? No.
Since I have approached all the concerned authorities.
But don't tell me the police authority.
Annex 2 SDPO, sorry, it is this is, in view of my application to the concerned authority, the concerned authority wrote for to SDPO Anandpur and the Superintendent of Police Kendujhar, page 46, and also Sub Anandpur. Annex to
But
two
page
team.
46, I could see that only the superintendent of that was closed in the month of January 2020.
My lord.
Not before 2020. 2019 was the order of this court.
In that letter number, in the reference, letter number 71 dated 9/1/2020.
Yes, where is your judgment?
Yeah, yes.
It's para 8 onwards. And this is with respect to sand query.
How this applies? Because this was a case where the lease determination was done. There was no prohibition on their part, on the part of the lessee to continue with the quarry. If he is prevented by any, say, the order of the court, if he is prevented by persons who are not supposed to take the law in their own. That in the paragraph 5 says that though there is no specific rule, but that does not really prevent the government to take a decision on their
Oh, there's no power of relaxation, my lords, because
It's not a question, sir. It's a question of a lease to be granted. It's in the contractual field.
yes, my lords, the lease was from the period 2016-17 to 2021, my lords.
But it appears that thereafter the litigation came.
Yes, my
You
lords.
have also admitted
That
that
is
the
right.
villagers were resisting him, preventing him from operating the quarry activities. Everything was done. Ultimately, you rejected everything, villagers' objection. Now they say that since I was unable to operate because of this extra force which been put on me, so please grant me some time so that I can continue with that.
Yes, my lords, so only the, if I may refer para 8 of this judgment, my lords, what in crux it says is that there has to be a provision under the lease for extension of time or under the rules for extension of time. And in this case also, there is no provision under the lease for extension of time nor under
This is paragraph 5 of this judgment.
this judgment. I have not seen, my lords.
Give them a draw. And this is the earlier judgment.
Only on those grounds, this judgment.
Look at this judgment, paragraph 5. Come to page 3. Same facts. Come to page 3, straight away, paragraph 5.
It's a sandstone quarry, my lords. In the facts, my lords, it's a
It
sand
is also
that, my lords.
outside the specified minor mineral. It is also
Sandstone.
It is not a sandstone. It is come to paragraph 5. It is a sand quarry. Third line in paragraph 4. The petitioner was prevented from operating the sand quarry, not sandstone.
And it's in para 2 where it's mentioned, my lords, sandstone quarry, my lords.
I did not know.
And sandstone is not in the exclusion, my lords.
But one time, this will be sand. Does it come under the specified mineral?
No, my lords.
No. The
No,
same thing.
No, my lord, sand, only exclusion, sand is excluded, my lord. Sandstone is not excluded, my lord.
What are you talking about?
The depth.
8.4 is applicable to a specified mineral.
Yes, my lord.
Right?
Yes, my lord.
Sandstone comes within the specified mineral. I'm asking. It does not come.
No, my lord.
If it does not come, then anything which does not come within that specified mineral, the judgment would be read in that.
My lord, what I am trying to say is, my lords, sandstone is not specifically excluded, my lords. What is excluded is.
Why it is not excluded? Show us that is there any special provision for sandstone?
My lords, because my
Show
lord,
us from the rule. Show us.
the specified minor mineral is all minor minerals, including decorative item other than minor minerals listed in serial number 2. Serial
So
number.
that's why I asked you a very specific question, whether the sandstone is within the specified mineral or outside the specified mineral. Means the meaning of the specified mineral or outside the
Within the
of
meaning, my lord. Within the meaning.
Show us how.
Because, my lords, here it mentioned all minor minerals, my lords. And if I refer to schedule 3, my lords.
Schedule
3, my lords.
3.
3. What is excluded is serial number 2.
What?
Ordinary clay, slit, Rehmati ordinary sand.
Is it ordinary stones or
Because it talks about, third paragraph talks about stone quarry.
2G? No, 2G is.
Schedule, how is schedule 3 is applicable?
My lords, the rule 3AA definition talks about, I'll just read my lords. Specified minor minerals mean all minor minerals, including decorative stones other than the minor minerals listed at serial number 2 of schedule 3, my lords. So what is excluded is serial number 2 of schedule 3. So that does not come under specified minor minerals. Sand is specifically excluded. It's mentioned, my lords.
I do not find there is. Where is G? G is a controlling office.
My lords, if I may.
Who is controlling?
3AA, my lords.
No, I understand.
Other than listed.
I understand.
So she's saying.
I am seriously asking, there is, because I find from there, is it ordinary stone or it is the.
Ordinary sand. Ordinary sand is excluded, my lords. And this judge.
Lead serial number.
Ordinary
Slowly
sand.
with me.
Ordinary sand other than used for industrial and
No,
prostate.
ordinary clay, silt, Rehmati, ordinary sand. Younger generation stops. The moment they want a catchword, they stop there. So they do not go further. That's the whole problem. So read further.
Other
Other than used for
than
industrial and prescribed purposes. From a brick earth, ordinary earth, moron, laterite, flats, ordinary boulders, road metals, including allets, chips, budgeries, and rock finds generated from stone crushed, gravels of ordinary stones, and river singles and the pickles. When occurring in the non-forest land, when available in any forest land. So, type of minerals which do not come under the specified minor mineral. It defines that who will be the authority to take care of that.
Yes, my lord. Yes, my lord.
It does not really take away the entire thing outside the purview thereof.
No, my lords.
Now, these provisions, this rule 8 is under chapter. Under which chapter?
It is under chapter, preliminary chapter, first chapter 1.
Chapter 1,
Yes, my lords.
correct?
Preliminary.
Is the preliminary chapter. Now, please tell me, if it is rule 8 is being the ordinary chapter or preliminary chapter, then how can you say that it will not apply when it applies to only specified minor mineral? Because chapter 2, it talks about from rule 9, specified minor minerals.
Now let's see, we may refer to 8 heading, my lords.
Yes.
Period for which prospecting license term, mining lease and quarry lease be granted for specified minor minerals, my lords. So this rule is applicable to specified minor minerals. The heading of the rule 8, my lords. And specified minor minerals
Yes, I got.
is defined under 3AA.
No, I understand. What is the unique feature of this sandstone? How it make a distinction or difference between a sand and the stone? What is the, I do not know. What is the distinguishing feature? Stone made up of sand, which can be converted into a sand, and a sand itself. Sandstone means what?
Sandstone is when cumulative because of water and exposure of the environment, the lot concentrates at a position like we see in the beaches. In the end, it becomes stone. That is what my common understanding is, Malats. Scientifically, I have
Not
to.
in that way. Stones cannot be congregated in that way unless it is something, some chemicals are added, but it cannot be.
If it is a natural phenomenon,
That will
then
mark.
you can't say chemical or it's
In
not
a, in a
it's
natural
a
phenomenon,
man-made, it's not a man-made stone.
yes, Lord.
It's a natural one. So its formation is very important.
Formation of the sands forms from the big pebbles. Big pebbles, sands form.
Not big pebbles.
Malats, for example, in
That's all.
It's one more thing, if I may refer to, my lord, schedule two, there's two heading, my lords. Ordinary sand and sandstone are two different headings. So if that is so, my lords, then what is excluded is ordinary sand and sandstone is not excluded. Because schedule two gives prices for rate of royalty, the two different heads. So those are considered under two different heads. 32 and 34.
This provisions are an appeal.
Yes, minus 46.
Would you like to lose forum or would you like?
You find the office of I'll go in the office.
Let him go to the alternative remedy.
Yes, my lords.
Which provision is this?
No, only
What is the order passed by you?
collector, my lords.
Collector. And against the order of the collector?
Now, my lords, because of the amendment, it has changed, my lords.
Now, after amendment, who is the appellator? Director?
Director, my lords.
Is to the RDs.
Huh?
RDs, Revenue Divisional Commission.
No, now,
Now,
after amendment, now it is
No.
within the domain of Steels and Mines Department.
as per schedule 4, my appellant authority is mining officer, my lords.
But here.
Here, because the order is by the collector.
Collector is higher in position than a mining officer or what?
Yes, my lords, higher in position.
In the place of director or deputy director.
Then it is, it's a possibility. See, let's see. Director.
Because earlier it was Tehsildar to collector, my lords. Collector to RDC, my lords. I have to cross check, my lords. This is what my memory recollects, my lords. That act is not there, my lords. The earlier unamended.
They are in 46, from collector to RDC. Collector was first by the-
Collector is director. This amendment has passed. That's why we are stuck up. Those concept of Tehsildar collector is gone. It has been transferred to a mining department now. I do not want that the appeal should be filed before an officer who is below in the rank of a.
Yes, sir. No, may I place now,
Yes,
go
sir.
46.
Director can be equated with director. If it is director, then
If
it
the order
is the appeals to the state law.
If the order passed by the DFO,
Check out. 46.
46.
46 after end, last two lines. Last two lines. 46. One.
This document. Well, if the order is passed by the deputy director and to the state government in the department.
Collector is equivalent to a director.
Well, it's a taken, I'll just check
Just check it.
the unamended provision.
And just show us. Will
Because the order of the High Court, because of which the collector passed an order, was before the amendment.
there are line of judgment of the Supreme Court says that by an order of the court, the jurisdiction cannot be conferred.
Yes, madam, so that's what I was.
So whatever be the reason, now the order has come.
Yes, madam.
So director can be equated with the collector.
Well, that is what I was precisely trying to say, because now the order has been passed by the collector. Under 46, there is no appellate provision against the order of the collector. Then it will be
Can
confirmed.
we perceive this order as an order of the director? Whether the director can be equated with collector?
Director is IAS.
Director is
Deputy director. Not your scheme, say, mining officer, then, deputy director, mines. What is the hierarchy which goes up to this mining department? Then,
the highest would be director, madam.
the IAS rank officer, at what stage comes?
Well, so far as collector is concerned, IS officer or an OS officer of senior administrative grade, SAG grade, they remain as collector. So far as the director and deputy director of mines.
Qualifications. Qualification of the director and deputy director of mines.
We are thinking in that line where by virtue of an amendment, the right to appeal is still intact. But the forum is created, and in that event, there is no impediment on the court to tailor that particular forum. When the right is still there. Say, I give you an example to understand that what is passing in our mind. This amendment was brought on a particular date. Prior to the date, the authority who was competent enough to take a decision has taken a decision. The period of limitation has not expired for filing. Now, a aggrieved person want to file an amendment. Can he be rendered forumless? When a forum is changed, nothing has happened.
Malice, if I may request for tomorrow, Malice, I'll take instruction, what is the rank and hierarchy?
So that is what we have to just take a pragmatic view of this. We will say that now, so we can direct him to file a appeal before the state government.
Yes, ma'am.
Let us think in that way, let him file the state government. Because the director, order of the director is amenable to be challenged before the state government.
State government.
So that's why we wanted whether we can equate the collector with the director.
You have different definitions also, but it is not clear. Deputy director you have, director you have, joint director you have, director of mines you have, additional director you have.
Persons, those who hold the post of collector or the director mines, they are all of senior administrative grade or IS officers. That is.
That's
So-
what you have to come forward.
Yes, yes. Tomorrow, if my lords,
No,
keep it
otherwise
tomorrow.
you have all additional director of mines,
Now,
director,
collector means the chief officer in charge of the revenue administration
Yes,
of a district.
yes.
And the director means
specified manner, somebody and for specified, other than specified manner, another.
There are different directives, different
Designation.
Yes.
Merely designation or their ranks? We want rank. We want that.
Your lordship wants rank. Here the
The collector's order is tested by an operating who is lower in rank.
yes.
It's not appropriate.
Earlier it was collector's order before the RDC, Revenue Divisional Commissioner.
You must have submitted.
Yes.
When you have.
Give it to the state. The state is the ultimate. They are all under the state.
And you have the power under 64 also.
That is the transitory powers.
If it out,
Transitory power, that is the six
relaxation.
or relaxation.
That was the direction of this court earlier.
The order passed with the collector.
Petitioning the register, some plus contractor. He has been executing various works under Water Resource Department since last 20 years. Maybe. He has never been a defaulter. He has never been remarked adversely for the quality of work, but he has no scar on his career as a contractor. But unfortunately, He has been blacklisted.
Where is the order of blacklist?
That is Annexure 8, my lord.
Essentially, it is
Page
the order of blacklisting.
Yes, my lord, that is page 56. In portions up to later number double and 10, it's so and so.
This, the construction of two numbers of this new spur and the spur or the renovation of five numbers of old spur. These are the false documents.
That is the new work, my lord, for which I applied. I anticipated.
No. The fabricated document.
That has been supplied giving to that work. That is that work. Their allegation is I have
This
given
work you have applied.
for a new work I have participated.
What is the new work?
That is the new work, the construction of two numbers.
Oh, and
And I will do that work I have given.
sir, madam, will you not spell out where is the shofar?
Page 50,
Page 51, my lord.
51 and 52. No, there were three showcase notice. What is and next is one showcase notice.
I was very
But will you not take a decision when you talk about the false? What is the falsity in it?
Yes, ma'am, that's the,
He has said that he has not filed any false document.
well, if I may
You
refer
have
to
to say that how it is false and fabricated.
page 52, my lords.
Show us, sir, in your order within 56, where is the finding that these are the false and fabricated? What is the source of arriving at the decision that it is a false and fabricated?
Let's if I may refer to page number 52, my lords. The
Please.
showcase notice.
Please.
52. Yes, my lords.
Yes, knowledge. Very difficult to.
Yes, yes, my lords.
Yes, tell me.
Fifth. My lords, fifth and sixth line, my lords. The authenticity of the certificate as well as the completion of work has already been obtained from the concerned so and so wide dated so and so. Hence it is concluded you have uploaded forged and fabricated
So
document.
what is that document?
So-
The concerned superintendent engineer that they never issued this document.
Yes, my lord, it's the paper, the page is not clear. It is.
Sir, it simply says authenticity of the certificate as well as the completion of work has already been obtained from the concerned superintendent engineer. Why is this letter dated such and such? Hence, it is concluded that you have uploaded the forged and fabricated. How?
My lords, one line prior, my lords, which
Where
is in
is that
progress.
one letter?
My lords, if I may read 1, 2, 3, fourth line, my lords.
Yes.
The work, about the execution of work within so and so, which is in progress. That's what is written, my lords. And what he has submitted is work completion.
You come to page,
So what is the document which he has produced? Madam, there are two things. One is that a document which he produced was never issued by the superintendent engineer. It is a forced document.
My lords, the entire.
Where is that authenticity that it is a forced document?
Well, it's the bid submitted. What I could gather from the writ petition is, my lords, the bid submitted contained a certificate showing that what work has been completed.
There,
And what,
please, there is a distinction that if your requirement is that you must submit a document relating to completion of the work. Right? He has submitted a document which says that it is in progress. So it may not be in conformity with the tender requirement.
vice versa.
You can make him ineligible. that you are not. One thing. Second scenario is that he has submitted a document showing that the work has been completed in conformity with the terms and conditions. But that document was never issued by a competent authority.
Well, it's what I
And
could,
there is the forgery which he has done. If you talk about the second aspect, then there should be some kind of information or a letter given to you that this document which he has submitted was not issued by us, is a forced document. It is in progress is one thing which makes him ineligible. But it is completely different when he submitted a document which was never issued by the authority.
well,
Where is that finding?
my lords, in the present case, the bid document is not annexed, my lords. So, my lords, and what was the requirement under the bid is also not known.
Blacklisting is a kind of a civil.
Yes, my lord.
When you are deciding the cause, you have to be very, very specific. And there should be a complete finding in this regard. That by a letter of the superintendent engineer dated such, it appears that this particular document which he has annexed was never issued by the superintendent engineer. If that being the position, we are at one with you.
Well, it's,
That is the false and fabricated law.
well, if I may be given one opportunity to get all the show cause notices which were sent to the petitioner, my lords, and also the lease deed, because the blacklisting refers to a clause in the bid document, my lords. In accordingly, because that refers, and there are two work which is mentioned in the blacklisting order regarding which the forged documents were given.
These are the two, 1 and 2 was, he says that these are the work for which the tender was floated. And he applied for these two work. It is not the work which he is doing it somewhere else or claims to have completed. No,
No, my lords, that the language is, my lords, is hereby,
in connection with I asked him,
and in the show cause reply also, he has given explanation to those words, my lords.
there is that. Then he must have misled us.
Page 50.
Then he is misleading us.
Before I participated in a new work, madam, I had only work at my hand, and that was completed. So I participated in the second work, the new
What
work.
was the second work?
That is
What was the nature of the second
mentioned
work?
in the order of blacklisting. That
This
is
is
the
what you are saying, but she is saying something different. She says that these two work
yes, madam.
is not relatable to the present work, but it is a past work for which you have to give a certificate.
The past
Certificate.
works
Certificate.
agreement
Petitioner
number for
does
the
not
past works.
specify for what work he had applied, my lords. There is no averment in the
That-
petition.
Yes, yes, that is there.
Madam,
That is there. That is agreement number 56P1 2223. That is the agreement of the first one which you was doing and the completed. I had no work pending at my hand. My lord. Then I participated in the second one and gave
Where
a,
is the second work? What is the second work?
my lord, that is
What is the second work?
Yes.
Was there any notice, NIT, notice inviting tender or any tender was floated?
my lord. That-
What? Tell us that what the tender was floated.
That
Operating in a different way.
no, that
You
is
are
the new one.
interpreting- I just, can you show me a tender that will eradicate anything?
Yes, my lord, I will try to collect that on this topic. Because this is the new article, which is so called 57 issued
We
to.
appreciate that is what he, but she's not agreeing. She says that these are the past work
No.
for which you claim that
Then my
it
lord,
is completed.
the so-called has been issued for that work. That you have
What is
given
a,
false.
I do not know, I am a very bad in English.
Thanks.
What it means, show cause notice for uploading and misleading documents for the work. I do not know what is the meaning of the word for the work. Means construction of two numbers. What does it mean? Is it a new work or it is the work for which you have given a certificate?
My previous work, I have, that is agreement number is different. Here I have not signed any agreement. And that work description is different, that is, that work is my lord, bank protection work on the left bank of a river Buddhabangal near village Bangalore.
You are hearing us now. Is it not your duty to write it with clarity? Show us from your petition.
And it's para 4 minutes. That's just a base five.
Now, bank protection work on left bank of river. But this is something different.
That's right, that was the work which has been completed by me and the next, the so-called has issued, that is the new work.
So she is correct. Well, she is correct. What you are saying is wrong.
My lord, for the new work, I have given certain information which they say that it is misleading and
Not misleading. It says it's a false and certificate.
false. I have said I completed the work, they say no work has not been completed.
You think she did not understand. So I accept it. 4 weeks, 1 week, 5 weeks.
Item number 8.
If I may please check. My lord, this is the action on the part of the authorities in not conducting the public hearing. And on the last occasion, the lordships were pleased to direct the state, Summit State Council to take instructions on this. Although 5th of August 2025 was declared to be the date, but it did not take place on that day.
My lords, the collector, my lords may see the instruction we have received. Here, the collector has asked for some clarification from the government. Lord may see the second page. My lord, therefore, my lord, this public hearing has been postponed, my lord, not cancelled. This has been postponed. There is no clarification received from the government. The second page, my lord, will see the letter of the collector. because the tender was of the year 2015-16. My lord, much time has now elapsed. Therefore, my lord, the collector wants clarification from the government as to whether a public hearing can be now held after 10 years. So once that instruction is received, my lord, if it is in favor of the petitioner, my lord, then the public hearing will be held and a new date will be fixed, my lord. That is what the instruction is given. And my lord, this reason has also been intimated to the petitioner. My lord, will see the last.
Is there any bar? I'm asking, is there any bar or a timeline which is given that within certain time you'll have to do a public hearing?
Not the EC, environmental clearance, my lord, that is granted by the Pollution Control Board. My lord.
Is not concerned. You have said that 10 years has elapsed.
No.
Whether we can proceed with the public hearing now.
No.
That means there must be some timeline which is given in the rule within which the public hearing has to be done.
Not the OMCC.
If there is nothing, there is what? What is the decision?
State Impact Assessment Authority.
It is that EC is granted by the State Impact Assessment Authority, my lord. My lord, whether in their rules, my lord, whether my lord, it has to
What
be
EC?
my lord, environmental clearance, my lord.
I'm not concerned. Public hearing means what? The grievance of the public has to be heard. Whether EC is granted or not granted is a separate issue.
No, it is for the reason, my lord, whether EC is to be granted or not. For that purpose, my lord, the public hearing is held, my lord. My lords will see.
Then the public will decide whether the EC will be granted or EC will not be granted.
No, my lord, my lords may see, my
If
lords.
the rule says that you have to grant, then you have to grant.
My lord, in the mining rules, mineral concession rules, my lord, there is no provision, my lord. But my lord will see why this public hearing has been held. My lord had been scheduled. My lords may turn to page 24, my lord. The Pollution Control Board says that request the collector to hold a public hearing. So this is the basis, my lords. My lords may see page 24.
So please hold the public hearing. Where is the bar?
Lords,
If after hearing the public, you find that there is no genuine grievance or sustainable grievance, then you will have to go to the Pollution Control Board or whoever to grant.
my lords may kindly see the rules, my lords. Rule 27.
Yes.
My lord, Rule 27 deals with grant of query lease. Grant of query lease. My lords may see clause 13. My lord, clause 13, the selected bidder shall be required to execute query lease in form N within clause 13, my lords. Of 20, Rule 27.
27.
My lords.
There is no clause 13 of Rule 27. Oh, this is the 2004. I understand. Oh. The requirement.
My lord, the requirement. My
Why
lords,
did you give them a permit?
my lord, the requirement is.
They can't continue with the query operation unless they have those certificates.
The environmental
I am
clearance.
asking you a public hearing, sir.
So for public hearing, my lord.
I am
no
asking
specific provision.
simply that public hearing has to be done.
My lord.
Under what provision the public hearing?
Yes,
Is
sir.
there any timeline fixed that within which that the public hearing has to be done? I'm asking you a very specific
My lord,
question.
in this rule, my lord, there is no provision for public hearing.
Then under what provision you are doing a public hearing? Tell me.
My lords may also see, for a moment, my lords may kindly bear with me. My lords, Rule 29, Clause 4. My lord will see that it is the responsibility of the lessee to get the environmental clearance. No, my lord,
Sir,
my lord,
please,
my lord will permit me.
Sir, I am asking you, suppose if we got all the license,
My lord.
the villagers or the public has come and raised an objection. You are holding a public hearing for what?
My lord, the collector holds a public hearing, my lord,
Why?
on the request of the Pollution Control Board, my lord, because
I am,
it is.
under what provision? I am
That
just
provision,
asking.
my lord.
That's why I am asking, sir.
Then my lords, may grant me one opportunity, my lord, I'll obtain under which provision or statute, my lord, that hasn't, because in the mining rules, it is not there, my lords. So, my lord, the pollution control board under which provision?
Can you enlighten me on this?
My lord, it is under the environmental impact assessment 2006.
Where?
My lord, I've just forwarded it to the soft copy I've forwarded, my lord, to the IT team, my lord. I have a soft copy, my lord. So we can just and WhatsApp coach. Helpline number is WhatsApp coach.
Yes, ma'am. Share copy. He has to join in the BC. He has to again join in the BC system.
This notification of 14 September?
2006, my lord, and its amendment subsequently in 2009. My lord, the procedure.
Which one?
My lord, procedure is there at Appendix 7, page 37 of the PDF.
Page 37. Scroll. Scroll it.
Yes. So this is the procedure wherein it is mentioned, and the process, it starts, my lord, the applicant shall make a request through a simple letter to the member secretary of the SPCB or Union Territory Pollution Control Committee in whose jurisdiction the project is located to arrange the public hearing within the prescribed statutory period. In case the project site exceeding beyond a state or union territory, the public hearing is mandated in each state or union territory in which
the timeline given?
yes, the timeline you also will see at the page number 39 of the PDF. Yes, 7.2, 7.1, or 7.2, the time period for completion.
45 days.
Yes, your lordship. And the default clause is 7.2. In case they are unable to do, then what would happen?
Any other agency or authority?
Yes. And in this case, your lordship will just see what has happened. The first letter of the State Pollution Control Board, Annexure 7, page 21, they direct all the authorities and me that you submit the necessary documents. I have done that. I have complied. Then the letters are issued to the collector and all the sub-panchayats of all the villages to conduct the public hearing. Then a date is fixed on 5th of August 2025. And the collector on his own motion also requests the police. Your lordship will see that letter. That is very important. Annexure 10, page 37. My lords have that. My lord, this is
Police person.
yes. Now they have asked for deputation on 31st of July, and it was supposed to be held on 5th of August, and they don't hold it, your lordship.
And the mandate has gone 45 days.
That is the reason, my lord, I've
We will take off from you and will entrust any other person. That's the consequence of 7.2. We are directing the central government, that's the Ministry of the Environmental and Forest, to engage another agency to conduct the public hearing. It's 7.2. The directive. That's the consequences.
Lord, as per 7.2, my lord.
45 days, leave the deadline within which it has to be done. If they do not, then the central agencies will.
But the pollution control board has not been added as an opposite party to the petition. Let's see. 7.2.
I was saying 7.2.
7.2, if the SPCB or the UTP system, SPCB is the State Pollution Control Board means, fails to hold the public hearing
Within,
within the stipulated 45 days,
Yeah.
the central government that.
so similarly to the central government.
You are not acting for the SPC.
SPCB, in fact, SPCB is not an opposite party. It's not a,
You are not acting.
no, it's like another thing.
You are not made them.
No, my lord, I was aggrieved by the inaction of the collector because SPCB has directed and mandated.
You are showing.
For each show, then you have not made a party. Now he has not done it. So it has to be. So we are permitting you to implement the.
Your lordship.
We will go to the petitioner to implement. It's not state issue.
Yes, sir.
State Pollution Control Board,
SPCB.
I wanted the union because central government.
State.
No.
Orissa State Pollution Control. So this is category A or category B? 7.2 refers to two things.
Yes.
Category A relates to environment is forest. Category B other than.
The state pollution control board. As a party.
Item 9.
Which was that, what do you say?
This one, lordship, in fact, this affidavit was prepared late in the evening on Friday. So it could not be filed today, my lord, today morning. But if your lordship will look at the affidavit as soon as it came to the notice, the Tahsildar has stopped the work. Yes. The lordship may kindly see the last annexure, annexure E/5 at page 10. He sought for a clarification from the BDO. Tahsildar sought for a clarification from the BDO, and after receiving the clarification, once he came to know that it's a Gochar land and construction works are being carried out, so he immediately directed to stop this and till the de-reservation process is to be.
The wishes after the resolution, they can do it.
My lord.
We are disposing of the matter.
Yes, sir.
The instant public interest.
Inspector of Excise, my lord, has sealed
Why so much of interest having shown to open the IMFL offshore? Let it remain
in order
closed for the
to, in
betterment
order
of
to
the
check,
inhabitants of the locality.
in order to check the illicit trade of it. So as to facilitate people to have genuine liquor, in order to check the sale of illicit liquors. I did. That is one. Two, state's revenue. Because NGQ and other things are bound by the licensing. But that is one part. The Lordship sees who has sealed. Sub Inspector of Excise has sealed. He has no authority to do that.
So,
But kindly see page
where
20.
is the order?
But there is no order, no notice, no order, no closure order, nothing. Straight away came and sealed the shop, page 21.
Page?
Page 21. This is photograph of sealing the shop, that's all.
And this is the letter at page 23.
That he has summoned me on the basis of a statement of a person who has made a statement before him that he has transported 12.5 liters of foreign liquor from my shop, that's all. A third person who is arrested, rather nabbed by the sub-inspector of excise, he makes a statement before him that 12.5 liters, 12.78 liters of foreign liquor is loaded from my school. That's all.
Loaded means you are offshore.
I'm the
Sell
offshore.
it.
He say that I have, at best he can say that I have purchased from me this person.
What is the purchase?
Yes, but there is a line there. Purchase, there is a limit described in the license. There is a limit.
At a time.
Yes, at a time, what extent of foreign liquor can be sold? License condition read with section 4 say 2.5 liters of foreign liquor, 5 liters of beer at a time can be sold. Nothing beyond that. And opening
No
a
person.
to
To an individual.
one individual. And working hours is also prescribed 10 a.m. to 10:30 p.m. He says that at 6 a.m. I have loaded this item from the shop of from my shop, but no material.
But where is?
That's the statement. That's the notice. Page 20.
Have we made an inquiry
No inquiry.
or any kind of a conducted an inquiry at no place going there,
No.
register?
No inquiry. And this is the notice given to me to appear before him. But apart from this, even if this is found to be proved, at best I am liable to pay a fine of rupees 50,000. No closure. It can't be closed on this ground because I have sold genuine liquors. I have only, at best they can say that I have sold beyond the permissible limit. And that is a compoundable kind of thing. Section 52. Odisha Excise Act, section 52.
Excise Act.
Right. First, your lordship will see before section 52, section 47. Section 47, grounds for cancellation of license.
40?
Section 47.
Grounds.
The power to cancel, suspend license, permit or pass.
It talks about the authority.
Yes. Then lordship will see section 52. It's a penal provision. 52A at best we may be attracted saying that it, without violating the condition, license condition.
47, you are saying this, the sub-inspector of excise is not competent.
Not
where is not competent.
But section 26 only.
20?
The power of the closure of the shop lies with the district magistrate, section 26. Section 26. That too, it can be for a period of 3 years with approval of the commissioner. They are beyond 3 days. I'm sorry, 3 days. I'm so sorry. 3 days. Section 26.
is how we can exercise. The power to suspend or power to cancel is one, then the power to temporarily close or seal.
That's this section 26 minutes. This is in regard to public peace. And let me see the last line.
No, let us see, does not apply. Where is the power conferred under the excise department to seal?
My lord, kindly see, there is a instruction, my lord, of the year 2024, my lord. It says, my lord, here, my lord, a case has been filed, open against the petitioner, my lord, PR case. My lord, this instruction says, my lord, during when a case is filed, my lord, then, my lord, the shop can be sealed.
Asking under what provision?
My lord, there is, under the act, there is no provision.
Then under the rule?
No, my lord, no provision is there to seal. But, my lord,
Can you take a power or exercise the power not vested in?
Lord, they have sealed it on the basis of this instruction. my lord.
Simply, that's why there must be a power that should emanate from the statutory provisions.
My lord, the power of seizure is there, but the power to seal is not there.
Then temporarily close is with the district magistrate.
Yes, my lord, that is there with the district magistrate, but that is under different circumstances. When there is
So
public
that means
peace and
sealing means you are really closing it.
My lord.
Temporarily.
my lords. So, my lords, they have done it on the basis of only this circular.
cannot be done.
This cannot be done. But, my lord may grant me one opportunity. This, my lord, I have got on my own efforts, my lord. I get instructions from the authorities, my lord, on what basis? Because I may be missing some provision, my lord, which may be there in the statute.
You cannot saddle him with other penalties. We will protect them. Something high-handedness has been perceived.
My lords.
Then you
If
cannot
there
saddle.
is provision, my lords, in the act or in the rules, my lord, then, my lords, this circular, my lords, will come into play. My lords, may
What
see.
circular?
My lord, if this circular empowers the inspector, my lord, to close the shop when an investigation is on, and, my lord, for a temporary period, and, my lords, after this case was registered, my lords, that's true, my lords. Statute, my lords, I could not find any provision in the statute, so that is what I'm saying, my lord, I'll obtain instructions. I could not find any provision.
No, that you're not missing. That circular is with regard to initiation of a case. That nothing has happened there. Yes, sir. Further date is fixed to 23/9. No further proceeding has taken place.
Sir, you take it. This letter also says that the power to see is not conferred on SIE. I'm reading for you, very interesting circular. It says that in inviting a reference to the subject cited above, I am directed to say that as per section 26(1), where the district magistrate's power is of the excise, Odisha Excise Act, the district magistrate or sub-divisional magistrate may by notice in writing to the licensee require that any shop in which the intoxicant is sold shall be closed at such time or for such period as it may think necessary for preservation of the public peace, provided that if the closure is required for a continuous period of more than 3 days, the approval of the excise commissioner shall be taken.
That is in tandem with section.
It is seen that number of proposals are being received at the excise directorate for continuance of the closure period for more than 3 days, where the shops are closed in course of the investigation, and in other matters where the provision of section 27(6)(1) is not applicable. Then, therefore, it is clarified that in case of a closure of any excise shop in course of any investigation, read it, sir, very slowly, and for any reason beyond the purview of section 21A, 26(1), the closing and opening is the sole prerogative of the investigating officer. And for such closure, no permission of any superior authority is required. If the closure of the shop is not required further for the purpose of investigation, the investigating officer, the concerned superintendent, should be open the shops. What does it mean?
If I may, my understanding will.
So first closure must come from the district magistrates. And continuance would be done by that particular department in the event it is the investigation is going on.
Look, from the district magistrate, my lord, it can only come under section 26, which provides, my lord,
That it says that which does not come under the purview, but it is required for the purpose of investigation, then they can continue. The purpose is that continuance without any reference to 26(1) is the imminent requirement.
my lord, section 26, my lord, it speaks of 3 days. That 3 days, my lord, is
Have
the,
you read the letter which you are relying on?
my lord.
Your letter says that this is what is the problem. It is a 3 days. Now, it appears that the district magistrate wanted this particular closure to continue beyond 3 days. Then they are approaching the excise department for the purpose of their permission or sanction. And there is a lot of applications which are pending at the excise department. Then to avoid this, that for the purpose of investigation, this may continue and no further approval is required.
My lord, section 26 does not provide for any investigation. It is not connected with investigation at all. Section 26, my lord, speaks of public order, my lord. If there is a possibility of breach of public order, law and order situation, my lord.
There is a provision for cancellation,
My lord.
suspension.
My lord.
You could have gone under that. But sealing is a temporary closure.
Temporary closure, my lord.
Then
But the problem is, my lord, another person has been arrested. That person gives a statement.
I am not going into the nuances of this.
My lord, so
Just reminding you of a 27 of section 27 of the evidence act.
my lord,
Just reminding you. That was in relation to a what, police. I'm just reminding.
my lord, so in this situation, my lord, I have not come across any provision in the act or the rules, my lord, which provides of sealing or closure of the excise shop. So, my lords, may grant me one opportunity to obtain instruction under which provision they have, if at all there is a provision, because I have not come across. I tried my best. I did not find any provision.
For attention is drawn the to room the Oh,
Item number 49, like a bad coin, I am coming back before your lordship over and over again. Well, that is,
it is still a credible point. Why are never bad? Has its value.
well, I don't know how long it will continue to remain, have value, ultimately.
What is this?
Well, at this matter, I made my submissions on this. It was not concluded. But well, it's quite some time back. I'm sure your lordship doesn't remember it because I have almost forgotten most of the points that I've argued. But this matter, my lord, kindly give a date, any date convenient to your lordship.
You're not saying anything in the register?
My lord, but can it be on the 23rd? 23rd, because I find, my lord, 20th and 21st, my lord, the courts will be closed.
Diwali.
For Diwali. And my lord, 23rd, can it be at 2 p.m.?
My lord, in the same set cause of action, another two matter is pending, 27665 and 27672, all are case matter. May I pray all three matters will be taken tomorrow? Only same set cause of action, nothing else only. No, my lord. No.
What is the difficulty?
Yes, my lord. No difficulties with my lord, but if all three matters will be taken tomorrow, today I am a little bit ill. If
The same tender.
Same tender, same cause of action.
Yes, somebody is appearing online.
Union of India. I had already served the copy.
Lordship, I am appearing on behalf of GEM, which is the intermediary on which portal the tender has been forwarded.
Okay.
And also I had
These two numbers.
27665 and 27672
25 of 2025.
of 2025. All fresh matters.
Submitted by the council for the resistance. I can't read it, sir.
Sir, my lords, I am sorry, but because of the sudden first tender, I had filed
I
it.
can't read this
I
document.
undertake.
The whole difficulty is. What is it?
Suddenly the capital.
Oh, I do not know. What is this?
All are in Odia vernacular. I'm
That
sorry.
is what I say.
I'm
I can't
extremely
read
sorry.
it, sir.
I beg apology. I beg apology.
If you can read it, I can understand.
Let's Annexure 4, page 22.
What it says.
That says that
I can read only Mahashoy. Thereafter,
thereafter, Lords, upon Lords in English or Odia,
in Odia.
fine. I'm grateful. ଆପଣ ଆମ ପଦ୍ମପୁର ଗ୍ରାମ ପଞ୍ଚାୟତର ସ୍ଥାୟୀ ସମ୍ପତ୍ତି ସିଆରି ଗେଟ୍ କୁ ଗେଟ୍ ଟିକୁ 2025-26 ଆର୍ଥିକ ବର୍ଷରେ ସର୍ବୋଚ୍ଚ ନିଲାମ ଡାକ 9,30,000 ଟଙ୍କାରେ ନେଇଥିଲେ। ଚିଠି ନମ୍ବର 13 ଡେଟେଡ୍ 3/6/25, ଚିଠି ନମ୍ବର 19 ଡେଟେଡ୍ 21/7/25, ଚିଠି ନମ୍ବର 20 ଡେଟେଡ୍ 31/7/25 ରିଖରେ 3 ଗୋଟି ପତ୍ର ମାଧ୍ୟମରେ ଜଣାଇବା ସତ୍ତ୍ୱେ ରସିଦ 39ରେ ଅମାନତ ରାଶି ବାବଦକୁ 45,210 ଟଙ୍କା ଏବଂ ବ୍ୟାଙ୍କ ଆକାଉଣ୍ଟ ମାଧ୍ୟମରେ 1,50,000 ଟଙ୍କା ରସିଦ ନମ୍ବର 34 ରସିଦ ନମ୍ବର 59ରେ 5,000 ଟଙ୍କା ମୋଟ 2,02,010 ଟଙ୍କା ଗ୍ରାମ ପଞ୍ଚାୟତ ପାଣ୍ଠିରେ ଜମା କରିଅଛନ୍ତି। ଅବଶିଷ୍ଟ 7,29,790 ଟଙ୍କା ମାତ୍ର ସମୟସୀମା ମଧ୍ୟରେ ଦାଖଲ କରିନଥିବାରୁ ଆପଣଙ୍କ ନିଲାମକୁ ଗ୍ରାମ ପଞ୍ଚାୟତ ବୈଠକରେ ଗ୍ରାମ ପଞ୍ଚାୟତ ନିୟମାବଳୀ 2014ର ଅଧିନିୟମ 48 ସବ ନିୟମ 12 ବଳରେ ଅବୈଧ ଘୋଷଣା କରାଗଲା। ତେଣୁ ଆପଣଙ୍କ 9/9/2025 ରିଖ ଠାରୁ ଗେଟ୍ ଆଦାୟ ନ କରିବା ପାଇଁ ଜଣାଇ ଦିଆଗଲା। This is a notice on the day itself that was cancelled without notice, without show cause. Immediately 2 days after, Annexure 4/1 was published for tender. Lords, accord with Lords.
So the only thing is that you were supposed to deposit 9 lakhs and all. You could only deposit 2 lakhs and all. Rest of the amount 7 lakhs and what you did not deposit. If you were the successful bidder and quoted the price, then you are supposed to deposit that amount.
My lord,
You did not.
Lord, this is a Lords, I was allotted in the month of May 2025. Lord, immediately next month, in the month of June 2025, third Lords occurred in the district, entire district, Jagatsinghpur, high flood. Therefore, Lords, I requested the collector kindly, this is the situation, allow me some time, I will deposit, and that is still substitutes.
You could not move out of your house.
Yes, Lords, nobody in the entire district, Lords. I have given the
What
paper.
was confined to is their house.
Yes, Lords. That was severely affected entire district.
I did not get the news.
Look, yes, paper publication, their Lords have enclosed.
Yes.
Entire district, Lords.
Everybody was confined in the house.
Yes, Lord. And the entire system was damaged. Jagatsinghpur district in the month of May.
Buildings were damaged by the flood.
Yes.
So no government was functioning.
No, my lords, that was functioning the sum after the resident of that fraud, my lords, what after the.
Just asking, sir, when you quoted the price, you were ready with the money.
Plus, I was expected to repay. Plus, I'm supposed to pay the money in each installment, but because of sudden
Why
fraud.
installment? There is, what was the conditions put?
No, there is nothing written regarding the installment.
That's why I'm saying, the condition was, what was the condition? That if he quoted the highest price, he has to pay within.
He has to pay immediately, my lord, because there is nothing.
So on that day, there was no flood.
Yes, sir, on the 23rd May, and next month, just 15 days after, the fraud came into the district.
You were supposed to deposit money when? After you were declared successful tenderer?
Within that month, so within that month.
Within a month?
Yes, yes. Yes, yes. And also the recent tender call notice, they have issued under Annex 4/8. Plus, they say.
What you were doing, this letter is of September.
Yeah.
Cancellation?
Cancellation immediately 2 days before, 9/9.
September.
Yes, yes.
Auction was held in May.
May, plus.
So.
Plus, I have a
June,
request.
July, August, 3 months.
Because I didn't ask anything because of that fraud, plus summons of the entire district.
You quoted the price in anticipation of that you will be earning.
No, plus, that is the plus the.
Three reminders were sent to him, my lord. Three reminders were sent to him. But it's apparent from page 28, my lord.
No reminder, plus nothing. They have quoted it, plus had it. They could have issued me so good notice. Why this?
Why?
The automatic.
If the conditions are that you will have to put the money, you did not admittedly put the money, then why show cause?
No, because your lordship, I have a deputy obeyed their lord's condition, deposited the money, plus the rest amount.
Where is the money?
Plus
Not.
rest 7 lakh some more. I was to pay in the next month, June. Plus in the month itself, May.
So you could have May, you could not do it. June, what you did?
Plus that was a damage.
July, what you did?
Plus that was a damage.
August, what you did?
Plus that was damage. For that Annex 3 was pending from the collector. I had requested the collector.
That you permit me to pay in the next year.
No, no. Some time may be allowed to me so that I can pay.
3 months time was enough for you.
No, Millers. In between Millers,
this is on the 9th of September.
Millers, in between Millers, this natural calamity came into the.
How long it continues?
Millers, a month or 2 Millers.
What? Everybody was.
The entire system is to be restored.
Improbable, unacceptable, sir. This cannot be done.
The third situation.
Flood may disrupt the life for some time, say 10 days, 15 days, I can understand.
1 month, 2 months, Millers.
But what about the third month?
Millers, we had requested therefore the collector, please, for this reason, allow some time. You also allow me also time, I can.
Sir, they waited till 9th. Had you gone there and offered that money to their price, they extended the time.
No, Millers, that is their Millers content, so that is not in fact. They could let them produce
Page
that.
28, he says.
No, that let them produce the letter that they have issued me, that warning letters that you pay, otherwise you cancel.
Necessary, sir.
Auction, your lordship knows, Supreme Court repeatedly said unilateral cancellation is not permitted.
No, in what circumstances?
No, this is the circumstances.
No, sir, this is an absolutely different case. If the tender provides that you'll have to deposit a particular amount within a time frame. If you did not deposit the amount, no so cause is required. Automatic consequences.
No, your lordship, kindly see one judgment I have. Recent judgment.
Please.
When was that allocated to me? Millers? May, Millers, May. These two judgments, your lordship, can you see cancellation of auction?
Please. Yes, which one you want to refer first?
Your lordship, kindly see paragraph 20.
Oh, this is the same judgment, 2 copies.
Sure.
Paragraph
20 Millers. This is also exactly what your lordship proposed, that the tender plus auction money was not deposited within 15 days from the date of selecting. Thereafter, your lordship can see.
Yes.
Para 20 years.
Anything more?
Lords,
Any other
therefore,
judgment, second judgment?
Lords,
This is a one judgment.
yes, Lords.
Any other judgment?
No, Lord, this I have. Lords, what I beg to submit to Lordship is that since we have requested the collector, this is the devastating situation because of fraud in the district. I could not pay, could not arrange the money because my business was sustained loss. Therefore, allow me some time. The collector is still sitting over my application for consideration. The BDO is a part of the system and one of the subordinate of the revenue authority. Lord, when the matter is sub judice before the collector to consider my grievance, that I am interested to pay back my money, but that is still under consideration by the collector. The sudden cancellation without giving a notice to me is not sustainable in law. Therefore, I have come to you also that illegal and arbitrary action of cancelling my auction and putting to fresh tender plus is under charge.
Why don't you refund the amount? Is there any forfeiture clause?
So far the present auction notice is concerned, there is a clause for forfeiture of the fund.
Yeah.
But then I have to take instructions whether in that auction notice that.
Another one, I beg pardon, Lords, one clause is there. There is a clause that this can be, Lords, again, time can be extended. There is a clause. And if for non-payment of the dues in time, the term of the tender, Lords, can be extended. That is one of the clause in the new tender. In my tender, they have no Lords, that is they are similar. Where is that? That I have not enforced.
Yes.
Similar, no, they cannot go Lords, in a different way.
Why not?
Yes.
And I can give you multiple judgments that it is the tendering authority who can put certain terms and conditions in the tender.
Different. But in my case, what I have had, Lords, I have accepted, Lords, that the similar condition was there in my case.
Then in that event, the forfeiture is one of the.
The forfeiture, they do not say. They say that they cancelled. Not had it been
So
so.
they have not forfeited your money.
Till that is still sub judice with them, the collector. And if your lordship inclined to allow me some time to clear the dues, your lordship allow that so that I can clear. No, it is for the interest of the Gram Panchayat. Lords, I am ready and willing to pay. Because of these circumstances, natural calamity, I could not pay minors.
Yes. But so far this annexure 3 is said to be pending for the collector Miller. But if you lordship kindly have a glance to that, there is no signature, no service of.
This is copy I have extracted. This is copy, not that.
It's correct. I would think.
Oh, now
There is no signature
this is the copy of the
and no postal receipt taken.
personally handed over collector. Language lordship, kindly allow me to read that annexure 3. There he has clearly stated that आपत्ति दरखास्तकारी मु श्री जयप्रकाश कांडी सा पोस्ट अलोरा ब्लॉक एरसमा थाना एरसमा जी जगतसिंहपुर निवेदन कारण एक जे मु नेइथिली किंतु दुखर विषय उक्त धार्य मूल्य मु ठीक समय पैठ करि पार नथिली एथि निमते मु 1,45,000 टंका पैठ करिछि किंतु दुखर विषय दुर्भाग्यवशतः उक्त पर्यटन स्थल रे विभिन्न कारणरू विभिन्न प्रकार दुर्घटना घटी जाई अछि जहा कि हजूरंक कर्णगोचर होई अछि प्रकाश थाउ कि समय क्रमे समुद्र ढेउ सियाली ग्राम को कूल उल्लंघन करी तथा पर्यटन समय कौन सी पर्यटन प्राण हराई दुर्घटना मध्य हजूर को आसी पर्यटन स्थली सियाली आज जनशून्य
ବିପର୍ଯ୍ୟୟ ଅବସ୍ଥାରେ ପହଞ୍ଚିଛି, ଯେଉଁଥିପାଇଁ ମୁଁ ମୋର ବକେୟା ପାଉଣା ଦେବା ପାଇଁ ଅସମର୍ଥ ହୋଇଅଛି। ଏଣୁ ବିନୀତ ପ୍ରାର୍ଥନା କରେ କି ଦୟା ପରବର୍ଷ ପୂର୍ବକ ମୁଁ ଆସନ୍ତା ଜାନୁଆରୀ ମାସ ପର୍ଯ୍ୟନ୍ତ ସମୟ ଭିକ୍ଷା କରୁଅଛି। ଦୟାକରି ମୋର ଆପତ୍ତି ଦରଖାସ୍ତଟିକୁ ବିଚାରକୁ ନିଆଯାଇ ମୋତେ ଉକ୍ତ ସମୟ ପର୍ଯ୍ୟନ୍ତ ସୁଯୋଗ ଦିଆଯିବା ସହ ସରକାରୀ ଧାର୍ଯ୍ୟ ମୂଲ୍ୟରୁ କିଛି ରିହାତି କରାଗଲେ ଅଧୁନା ଚିରପ୍ରକୃତ ହେବ।
Update for
8 minutes. 8-10 minutes.
as per has gone.
Yes, please.
No, this was cancelled. Nobody came and responded to this.
Why you challenging?
Lord's cancellation I have also challenged. Annexer 4. Cancellation as well as order putting in the phrase for phrase section.
No. Yes, you are representing the whole set of the response.
No, minute. The annexure 4 is issued by the Gram Panchayat. Gram Panchayat need to
Different lawyer or you can represent?
notice will OP should be issued.
Go the notice.
OP number 4.
29. This is
To give the requisite ammunition to your lordships to blast paragraph 19.
Yeah, I think, Manoj, I found out that the answer to the riddle that Glaxo, in fact, this is the answer lies in the ONGC. It's a judgment 2018. It's in section 125 of the Electricity Act. So the judgment of the ONGC, which was relied upon by the Glaxo at paragraph 19, is in fact in the statutory appeal. Section 125 is a statutory appeal. That was involved in the ONGC. ONGC was picked up by the Glaxo on the premise that after the limitation, the court has no power because the Supreme Court was exercising statutory appeal powers.
the difficulty is, I tell you, what you wanted to say, can we make a clarification of the order passed by the Supreme Court that
Your lordship need not have to go into that.
because that paragraph is more omnibus. Not just we wanted whether there can be any curtailment of a right to invoke Article 227.
No, that's not. Even the
It cannot, there cannot. Only thing is that it's a discretion which is left to the court. Whether to interfere or not to interfere. So that is always there. Here the language is as such that if he comes after this, no other option but to dismiss. In that, I wanted all of you to.
Lord, it is actually that paragraph 19.
Against this
Yeah, we'll come.
rejection of appeal.
Correct.
You have a remedy.
Yes, we have. It
You
is in
have
fact,
it.
yes, Lord, it is in fact the Glaxo, the paragraph 1, which actually framed the question, pursuant to which the paragraph 19 was given, Manoj, the answer. That is in the context of the ONGC. That's the answer lies in the paragraph 19. My learned friends are all asking about another date, Manoj. But at least we can put up for another date. I have no problem. But I have an answer directly on that. And that particular paragraph itself actually says that the court has, and in fact, the ONGC doesn't deal with the 226, which the paragraph 19 of the Glaxo.
No, that was the statutory appeal.
Correct.
Actually, Electricity Act.
Correct, Manoj. Correct.
When it talks about the writ remedy being curbed or being brindled or curtailed by certain. Then
It has also to be
consider
seen.
that whether this omnibus, I would say the declaration of law, whether it applies in a uniform manner or.
The issue framed at para 1 says, if a petition, whether the rejudication would lie only on the ground, that there is the statutory appeal has become infructuous on account of the limitation. That's only on one solitary ground. That's how the framing of question.
Also, here, clear stated that there is already a statutory appeal period of limitation provided. It has now, the doors of the first appeal has now been closed.
Yes.
Because of the outer cap or the outer limit being set forth in the statute. So in that event, this
Yes.
will also come here.
No, I tell you, the para 19, if your lordship will see the last three lines, it says that if we do this, then we'll be infracting the ONGC. And ONGC is not dealing 226. ONGC is not dealing with, it's actually dealing with the.
Well, one thing is that particular notion or the principles akin to a certain principles, if those are borrowed in another grammar, that is what permissible. We have to see whether this authoritative observation satisfies the ingredient of Article 141.
Correct.
And if it satisfies, then in that event, we have to find out a ratio descendant.
Correct.
If it is a ratio descendant, which is binding on us.
Correct, Lord.
Now, I understand there are line of judgment says that in order to cull out the ratio of the judgment, one has to look into the facts.
Correct.
And the context in which such observations have come. I am conscious.
Absolutely.
But I have read those judgments, that judgment, but I find it is a very uniform
And interestingly,
and omnibus.
no, the interestingly, if your lordship will see the para 1, read with 20. Well, with interest. Paragraph post 19. The
Ready, because from various aspects of the matter, we have to look into it.
My lord, can I submit one thing, ma'am? And that is in our item, my lord, item 28, I have challenged the wires of that particular 1074.
That is a different matter. Let it be rich. Let it
No, why it is different? Because that
here, what is the difference? Because in all these matters where my Lawrence seniors are appearing, in these cases, they have not gone into appeal. Instead of going to appeal, see, appeal is time barred, they are come under Article 226.
Here I have gone into appeal. They say that it is time barred. Same thing, my lord. I filed my appeal, it is time barred. And now I'm challenging.
Let it be argued.
It is also time barred. They say it is time barred. The same thing. They have not gone before the appeal and I have gone before the appeal. So it is time barred. And they asked me that they issued me an SCN, my lord, that show-cause notice.
So why you people, sir, not getting prepared?
No, my lord, may I fix a date, my
It's been
lord.
such a long time. I think one weekend was enough for all of you to.
It's a lack of coordination because of the.
Lordships, if I may submit.
It's an individual exercise, sir.
With the Lordship's permission, Lordship, in fact, there is.
Let all of you do the individual exercise.
My lord.
I gave you some lead while interacting with him.
No, I'm ready actually. My learned friend wants another day, no problem. But I'm ready with all the judgments.
My lords, I'm appearing with the GST department. Lordship, am I audible? Lordship, in fact, there is a judgment of your Lordships, authored by Justice Raman and yourself.
Many
judgment of this honorable court.
Coordinate bench judgments are there. So let it be
coordinate bench judgment being followed.
We have all that.
And Glaxo has been followed by at least, my lords, 3 or 4 high courts of this country.
Understand. There are judgments which are again I say that there is a distinction between the exercise of discretion.
Indeed, my lords.
a curtailment of powers in an absolute terms.
Yes, my lords.
If it is a discretion in a deserving cases, it depends upon the facts of the each case. Sometimes the court may refuse to exercise a discretion, sometimes on a very special or a peculiar fact, the court exercises the jurisdiction.
Indeed, my lords.
When there is an absolute embargo which is created, that under any circumstances, the court cannot go beyond this, then one has to understand that whether there can be an absolute and unbridled curtailment of the powers conferred upon the writ courts.
I quite understand what, my lords, what is falling for lords.
We are grappling with, or we are considering the such point.
Yes, my lords.
We have refused, in some cases, we have refused to exercise discretion because we find the peculiarity of the fact.
Indeed, my lords.
Warrant any discretion to be exercised.
I bow down, my lords. That's absolutely correct, my lords. Because there has to be a just approach to the issue, my lords, being that in genuine cases of hardship, where the petitioner was prevented from approaching.
What is there, because the language, or if we have to perceive the judgment in such manner, then we'll have to. Now, what is the extreme and extraordinary circumstances it depends.
Absolutely, my lords.
It's more subjective.
Yes. Indeed. There can never be an absolute fetter in a lordship's called under 226.
That provision has to be stated and to be tested with the on the face of the constitution, whether the
but they cannot circumvent the statutory route and come before your lordships after the statutory period is over and make the whole provision redundant. That is the whole purpose.
What the Glaxophil matter they say is that you can't circumvent that particular statutory provisions. If you have not approached the court, then in that event, it forecloses on your door.
Absolutely.
Not maintainable, it says.
Absolutely.
There are two things. It's not entertainable is one. This is not maintainable.
Yes, ma'am.
Glaxo case is actually that the party did not go. Party did go. Then the court did not exercise by saying it should not be exercised in a matter of course. That's the para 19 itself.
Because in fact, the court said, relying on string enterprises.
What my learned friend is trying to create an impression as if
no, I'm not creating any impression.
That's not the case.
My lords, in fact, the Honorable Supreme Court in Glaxo said, what the Honorable Supreme Court cannot do under Article 142, the High Court cannot do under 226. That is the express language in Glaxo, my lords.
This
is the exact case, my lords. Without disclosing under what circumstances this court should interfere, my friend has approached this Honorable Court.
That is what is the difference. That's the facts of the case.
Yes, my lords.
Let us see.
There is no such special circumstances made out, my lords, for
this situation. Let us go through it. Let us decide.
Lords, I will give a list of all the judgments of other high courts where they followed Glaxo.
Your counterpart must be there to pass on.
My lords.
First time ever in the history, 2020 came, premised on 2018, which is actually a statutory procedure. Nothing to do with 226.
Now with the line up.
I have come up with everything. But your lordship's
how to deal with the judgments.
Yes.
How to interpret a judgment.
And whether it is obiter dicta.
Now question is that sometimes this old notion that the obiter dicta is not binding, but now obiter dicta is also binding on the court.
Provided the issue is framed.
Say whether those observations are germane to a cause of action.
Correct.
This is what one has to understand in this. So please come with the line of evidence where can there be any curtailment of those constitutional rights or the remedies which is provided in the Constitution. How to interpret a judgment and to apply in a particular situations. How the observations are to be read. These lines.
Stare decisis, ratio decidendi.
Stare decisis is something different, where you cannot upset abruptly to a particular notions which is prevalent for decades or more.
Correct.
So it has to go in that.
No, on the last occasion, Lordship posed that questions. We have all those components are separately on the one page each.
You have to, yes, we will consider in that way that the long drawn
Yes.
method it has been upset there.
And clearly, Lord, this judgment starts by saying when there is a rule of alternative interpretation, I mean alternative forum. Now here the court then as staring to a situation where post that extended period, further period, there is no alternative forum. That itself also creates a inherent contradiction, Lord. Because that actually the rule of alternative forum exists. But in a situation like we are staring at, is actually there is no alternative situation exists. And on the contrary, the language of the statute says that the adjudicating authority will not grant. But that doesn't extend to the read court power. That's how the 246, your lordships knows that Mafatlal, then the El Chandra judgment and all. That all is saying that
El Chandra Kumar is on a different note.
The cat.
Whether by virtue of a
constitutional amendment,
legislative PR, you can take away the Article 226.
Correct.
Because relying on Keshwan and Bharti's judgment is a basic structure theory that was brought. The nine judge bench or a
seven, 1997.
97.
But Mafatlal is 9 judge.
9 judge.
Yes. And that is on the principle of the refund of unjust enrichment, section 11 every.
In fact, Mafatlal is in favor of the department because it says that all refunds are statutory, my lords.
Yeah.
So he can't rely on Mafatlal to his benefit, my lords. Mafatlal, in fact,
But the para 19 itself says, para 19 itself, which my understand is relying, actually is supporting my case.
When
the sixth, we all agree on sixth.
My lord,
it's a very interesting point, I tell you.
Yes, my lord, please.
We'll try to distribute some components amongst each other to make it more potent and effective. We'll be kindly posted as a 6th of November.
Nobody is really putting efforts into it.
My lords, in fact, I am carrying the copy of that.
I would love to be wrong, but
my lord, I'm sorry, my lord. This is my first time. I'll try and put my effort, my lord. My lord, can my lord bring it on 10th? My lord, on no,
What is the one data? This is 6 one day.
Yes. 10th or 11th, my lord, may fix up any date on 10th or 11th. Yes, my lord, I have challenged.
His matter may be detailed from this.
I am not opening my mouth, you know. If I open, I will make them a big visor. I'm not opening. We want everything will be decided at one go.
Right.
Then we'll go enter into the facts of it.
Item 20, it is a different matter.
You want me to disclose
No.
my mind,
No.
which will.
I can
do
understand.
not know which
I
way-
can understand your lordship. Your lordship. I know.
Perhaps the only issue which will grapple your lordship's consideration is that whether it is a ratio decidendi which your lordships will be bounded under Article 141 to that limited extent, actually my entire endeavor. Otherwise, the facts of the case, the questions are framed, and then the answer.
What I am at, we have to decide it.
And according to my finding, lords, there is no ratio decidendi here. In fact, the 19 itself dilutes that proposition. 10th November. Lord, may I request, lords, can it be a particular time, 2 o'clock, lords? Because lords, I come from the Delhi. I would love to be a participant. Lords, my other seniors are here all, and I'll assist at the best possible way. 2 o'clock.
17th October this month.
10th of November, 2 o'clock.
That 27th. 27th. No.
2 p.m. So much obliged. Thank you so much.
Item 2.
So I have a small prayer in item 20. It is small prayer, your lordship, subject to your lordship's acceptance. He has challenged the virus of the 107 crore. he has not made party neither Union of India nor state government nor GST council.
I'll make it.
All these three are bound to be a party.
To add the Union of India,
GST council,
the GST
constitution and state.
Twenty-three.
23,
24, that is that with this.
24 is what?
Right up to 28 perhaps.
25 also.
25.
25?
Yeah.
Separate one.
26.
26. Yes, yes.
That's matter.
Grateful members.
Provided the copies, what you let's say the observing order, they provide the copies based on which they make a satisfaction under section 148 in the Act. They provide the copies. That is provided to the copy.
Yes, well, I will.
Yes. Yes.
Yes. Right. 26. That is 22. 22. Item 27.
But it has to be 10. Tribunal 10%.
So now you can file an appeal there.
Just the portal is not functioning. See now, portal is not functioning. Till now, portal is not functioning.
Portal is functioning.
You see, portal is just functioning, but he may not file. One time period has been fixed. One time period has been fixed from which date to which date the order has been passed. That needs to be filed by which date, or everything has to be completed.
June of 2026 as the date to which appeal may be filed before the appeal tribunal. Where the order sought to be appealed is communicated to the person preparing the appeal before first day of April 2026.
Right. So, so many appeals now. In order to avoid the blocking, your lordship may kindly tell me. So this is what I want.
First day of April 2026. If it is communicated to any, they can file an appeal. 26.
Your lordship, up to June 26 is the last date.
June 2026, he can file those against those orders which are communicated to him prior to first day of April 2026.
Yes.
So means it is not expired.
Not expired.
So any order which is now communicated, he has a right to file an appeal before that. Now he says that portal is not functional.
Your lordship, that is for that reason I am saying.
Say up to such and such what?
Portal has been opened, but we have segregated. What I have got.
How can you segregate?
Because the server.
No. Your lordship, from 2018 till date, many orders have been passed by the past.
Does this
By that, your lordship may kindly look into.
What is that?
This is one clarification.
Okay.
Just to analyze that.
Sir,
that is the notification.
Sir, this is the notification in exercise of powers conferred by.
I'm not disputing your lordship. I'm only in order to avoid the loss, the year-wise segregation has been made. for example, as the for APL 1-2 period commencing on 24/9/2005 and ending on 31st/10/2005, who will they file? The order which has been uploaded in the common portal on 31st January 2020. All the orders which have been uploaded in the portal by 31st January 2022, those appeals are to be filed by 24/9 September 2025 to 31st October 2025. During this period, all those orders should be segregating. It is just segregating, or else from 2000 or else 2018 to 25. So many appeals.
Oh, about that deadline.
Your Lordship, there is a.
I'm really surprised. I wanted these officers to be present.
It's just your
That's why I'm asking them.
Your Lordship, because we have
A statutory notification issued by a competent authority gives them a right to file an appeal till June or something 2026.
June 26.
Okay, an executive instruction without any statutory powers being conferred, restrict that right of appeal, restrict.
No.
Now kindly consider, you say that from 2005 onwards, the appeal can be filed if uploaded before 2022, whatever the date, which can be filed within this gap of 1 month. Means
the 30th June. Last period is there. The offer limit is there. Your Lordship, because that cannot be violated.
you say between this period.
Only to backlog. Clear the backlog. Within that period you file, and if you cannot file, then up to 30th June your time limit is there. So in this way, all the 1 month time, whoever not filed, maximum they have to file by 30th June. Every time period that has been written. Only this is in order to adjust, in order to.
Then say with clear precision that you were arguing in such a pattern that it creates, I think there was a little confusion, but it becomes a use. You say that in order to streamline, because there will be a complete, the like a traffic jam in our system if everybody comes at one time.
Exactly.
So what you say that you have segregated appeals between this to this up to this period you can file. Between this to this up to this period. But what now you say that even if you could not file it within that period, this portal remained open for you. You can continue and filing it even during those.
The language is period commencing on 24/9/2025 and ending on 31st/10 or any date succeeding such date being not later than 30th June 2026. So the portal is open to balance to avoid traffic.
You can file it, no problem.
We'll file.
Pertaining to 2005. Your matter.
Yes, I will file, but till that date, I will.
The date is already there. You said the portal is not accepting. They say the portal is ready. If you come within that period, the portal is ready. And the portal will be ready for another period. The outer limit is still there. They have not bring any flexibility into it. very clear. Yes, we'll pass the order. You can file an appeal. 10% let him deposit with you.
Item 28.
Oh, that will be in works.
Item 22.
We'll say that.
To 30th June. So the limitation, because it is against 1st of 212.
31st of January 2022, you have opened the portal till October. But suppose any order which is uploaded after 31st of January 2022, say the 1st February, then you have said that the portal would be ready to accept the appeal after on and from 1st of November. The 1st of November has not come. So we'll say, just to avoid anything, limitation is not a question of limitation. The question is recovery. If the limitation has not expired, will you stop recovery? You will continue with the appeal is filed, nothing is there, it will proceed with the recovery. So if they deposit 10%, at least the recovery procedure is stopped.
Same order, for some days you let's see, the same order may be continued.
Oh, we are doing that, and let them, we are adding one line that because of this advisory, the time has come, they are open. And the moment they file the appeal, they will mention the matter before us. So that we can dispose of the matter and let it be decided there. I have to just argue like a lawyer to make you understand. Don't you understand what we want to do?
I'm sorry.
Yes.
Item 29.
This is what.
Item 29.
Small matter.
Oh, when you are appearing in a small matter, you will make it more complicated. Yes.
The last minute that I am challenging one judgment, that the facts of the case is that I am continuing as Anganwadi worker and one appeal filed against me that on the date of last submission of application, I don't have that resident certificate. My case before your lordship is that the advertisement did stipulate that you have to submit the resident certificate. On the date of verification, I have the resident certificate and it was verified and I got appointment. My lord, that the honorable single judge have given that on the last date of application, I have not filed the resident certificate because I married into that delays before 1 month and I applied for resident certificate. I am more meritorious, so I got it. And on the date of verification, that was there. But on 16th date was the date of verification. Due to public holiday, the sub-collector, the selection committee chairman, just postponed the date of verification. That was the issue that my appointment has been set aside. And that was before. I disagree.
The writ petition is dismissed, reward of merit.
My lord. And that is the only
That be set aside by the appellate authority or something.
No. Against me, my friend has filed an appeal.
Correct.
And
So appellate authority.
Appellate authority, I have given the verdict against me. Because
Say they set aside your appointment.
No.
Say by a single judge. So that's why I was.
Then thereafter, this honorable court passed an interim order and I was continuing my. My lord, lordship kindly see, this is the two grounds.
Show me the advertisement.
My lord, that is in Oriya. I have given the English translation. Here, lordship once heard it, but my lord, that is the English translation. And the stipulation is that hey, that means he must be hailing from that area, but resident certificate is not mandatory to be filed, my lord. Kindly see. The first condition, প্রার্থিনী অঙ্গনবাড়ি কেন্দ্র অন্তর্ভুক্ত গ্রাম বা পড়ানো
House number 1 of Chatendra Sahu.
Right.
To house number 212 of Bhagavantu
I am coming under that. I am coming under that, my lord. My eligibility is that I belong to that. But that is the only thing, my lord, that has my lord.
Does not talk about the residential certificate.
To be submitted, that is not there. And that's my case.
It's not here.
My lord.
Later on. You have furnished the residential certificate later on.
On date of verification. That is it's
A resident between these two houses. Yes, there is no stipulation that the residential certificate, only stipulation is must be a permanent resident of a house which is between house number 1 to house number 212. And admittedly, she is residing in a house in between that. There is no mandate. Other certificates, there is a mandate. They have to submit.
But your lordship, there is a procedure from the Anganwadi workers.
Where is the procedure? If this is the advertisement, then what is the procedure?
Guidelines for Anganwadi workers.
What?
It says here, 15 days time will be given to the candidates to apply to the CDPO along with the documents in support of nativity, educational qualification, caste certificate, and any other. The receipt of application shall be authorized by the CDPO. On 16th day of CDPO, the 16th day, the CDPO will verify the documents of the applicants in their presence and will notify the name of the.
But sir, there is a mandate of giving a certificate along with an application. I do not find there are certain certificates which says must be submitted. And then it says all such documents must be duly verified by a gazetted officer. But it does not talk about the residential certificate, may be approved, they have to submit. They have said, I am residing or permanently residing in house number 10. At the time of verification, they will come and say that yes, this is what the document is. No mandate.
But the guidelines
Where is the guideline? It does not talk about the guideline.
Get the B point.
I do not find the language is such that it must be accompanied by an application. I do not. And secondly, the advertisement will be a deciding factor. If the advertisement does not prescribe for the same, then
But on date of the submission of the application, our application was not complete.
where is the requirement, sir?
Sir, it is written in the advertisement. There,
Yes, tell me.
ଦ୍ୱାରା ବେଲଙ୍ଗ ସମନ୍ୱିତ ଶିଶୁ ବିକାଶ ସେବା ପ୍ରକଳ୍ପ ଅନ୍ତର୍ଗତ ମୋର୍ତାରୀ ଗ୍ରାମ ପଞ୍ଚାୟତ ମୋର୍ତାରୀ ଗ୍ରାମର ସର୍ବସାଧାରଣ ଅବଗତ ନିମନ୍ତେ ଜଣାଇ ଦିଆଯାଇଛି ଯେ ଉପରୋକ୍ତ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରରେ ଅଙ୍ଗନବାଡି କର୍ମୀ ମନୋନୟନ ନିମନ୍ତେ ସମ୍ପୃକ୍ତ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ଅଞ୍ଚଳରେ ପ୍ରାର୍ଥୀମାନଙ୍କୁ ତା 22/6/2016 ତାରିଖରୁ ତା 7/7/2016 ତାରିଖ ପର୍ଯ୍ୟନ୍ତ କାର୍ଯ୍ୟକାରୀ ଦିବସରେ
Condition is sir, the first condition still must be not permanent present. Is there any requirement in that clause number 1 to show that there must be a document included to that delivery? And then other conditions if you come,
but it is written in the
other conditions if you come, ପିତୃମାତୃ ବିନା ନିରାଶ୍ରୟ ବାଳିକାଙ୍କୁ ସମ୍ପୃକ୍ତ ସ୍ଥାନର ସାର୍ଟିଫିକେଟ ବା ନକଲ ଦାଖଲ କରିବେ thereafter ଫଟୋ ଦାଖଲ କରିବେ thereafter ଏହାର ପ୍ରମାଣ ପତ୍ରର ନକଲ ଦାଖଲ କରିବେ all other requirement is you have to furnish proof for as so far as clause number 1 is concerned, so far as residential certificate is concerned, there is no requirement. That is what our case is. Can you demonstrate from this that there is a requirement, mandatory requirement under this advertisement, and she has not furnished the residential proof at the time of her selection or verification? Is it your case that she is not a resident of this house number 1 to 212? Is it your case? Can you demonstrate? What is it?
One has to be read with 9. The lordship may find this.
Yes, I have read. What it says, now it says all documents must be attested by a gazetted officer. If there is no stipulation that this document must be there, in other cases you have said must be submitted, then what does it mean? I'm talking about clause 3. It says that minimum educational qualification, the applicant shall submit the Xerox copy of the matriculation certificate. Submit. 4 says proof of caste certificate, submit. Shall submit the proof of. 5 says if he is a parentless or destitute, the certificate of the concerned organization must be submitted. The word is submitted. Then 6 is if it is a physically handicapped, disabled certificate with the photograph must be submitted. If he is a divorcee, then a proof of degree for divorce is to be submitted. And then if he is qualified educational qualification, complete the certificate. If he is ECC, but the certificate to be submitted. And then 9 says all such documents to be submitted must be attested by one gazetted officer. So far as one is concerned, you did not say that the proof of residential certificate must be submitted.
But her case is that she submitted her residential certificate.
Sir, there are two aspects. What her case is, if I correctly understood, and the single bench has proceeded on a wrong premise. Her case is that since the advertisement does not stipulate the submission of the residential certificate along with the application, she did not submit.
She submitted on the date of verification.
But she disclosed that I am a resident of this house, which comes within that bracket. At the time of verification, she submitted the residential certificate. Must have been issued after the last date of her application. Let us go to that extreme.
That is there. It is the
Last date of her. Now,
beyond the last date.
It's committed beyond the last time.
now, if there was no stipulation in the advertisement that the certificate of residence must be issued prior to the last date of submission, then if she submits only the proof, because only to ascertain that his or her house falls within this term. Yes, proof. Then the court has proceeded that the application was incomplete.
But the court has proceeded on two counts. One, the application was submitted, the residential certificate was submitted beyond the date. Number two, the selection, because the selection, the entire selection was set aside by the collector, the appellate authority, on the ground that the next date, as per the guidelines, the next date of selection would be on the verification date would be on the 16th day of the last date.
16th day was a holiday.
16th day was a holiday.
So 17th day it was done.
It was not done. That is what is the case, man.
It was done.
It was not done on the
It was done
17th.
on 17th day.
No, man.
That was a public holiday 17th. That's why.
Oh, 17th was also
Also
public
public.
holiday.
Madam, page 56. There it is there, CTPO to sub-collector, that thereafter 9/7 and 10/7/2001 government holidays as reveals from record, the sub-collector Puri is kind order on 36/2006 fixed the verification program on 12/7/2016.
What about 11th?
11th was a working day, but on that day verification was not
There was no
there. Because my lord, this
And
is
16th day expires when?
that is on 7/7. There is a long holiday. So the sub-collector was on leave actually. That was my information. I cannot prove it. I have obtained through ITS, but it's
Current 12 of the
12 orders. So on 7 is a government holiday, 8 is a government holiday, 9th is a government holiday, 10th is also a government holiday. So 11th is the only date left for the verification. And that is a government guideline. That is not statutory.
Current signature says nothing is mentioned in.
But on the same ground.
Why? 11/7/2016.
Yes.
Though a working day. Skip.
Well, only that day.
Now tell me, where is the statutory provision?
No, there is only instructions. There is no statutory.
Where is the statutory provision? 16th day.
There is executive instructions. Guidelines.
Guidelines.
C point.
No, only guidelines, executive instructions. There is no statute operating the field of Anganwadi worker selection.
It is on the guidelines. Sir.
Para 11, Honorable Single Judge has precisely explained it.
2007 guideline. Only one working day skipped by the sub-collector. It is not disputed that next working day was 11/7. The petitioner submitted the undertaking to the effect that she has applied for residence certificate. Because of the holiday, she was on leave.
No. 8/7.
Yes, sir. C point.
B and C.
B and C.
the next working day.
Yes, sir.
If it is not done by the.
Where is the consequence provided? Where is the consequence provided? If it is not done on the 16th day, it will, no power is reserved. Then a particular provision becomes mandatory if the consequence is provided therefore.
God, order of the circumstance is not revealing that.
Madam, come prepared.
Hello.
First thing is, what is the nature of these guidelines?
There is executive instructions.
Whether it has got any statute? No, this guidelines is issued by
This is a.
the Women and Children Development Department.
Every year that has
This
changed.
is what is there.
Every year it is changed, right? Every year. This is as per the advertisement 2007. Now new
Or you
guidelines.
have to say that what are the powers, whether the commissioner, some secretary can issue such kind of an instruction, or it should be done in the name of a governor. If anything is to be done, please come with that, whether it is an executive instruction or as a statutory flavor. Secondly, in order to render any provision mandatory, what are the parameters one should look into it?
I remember similar case, because our honorable single judge allowed one case and I have cited. That is also my honorable single judge has
You want
cited.
authoritative judgment or you want go by that?
No, I'm just submitting. I'm just submitting.
We are not
It
getting
is
what.
yes, it's a privilege to sit here and hear this court because it gives us clutter in mind.
Driving your attention to some other. Oh,
Yes. But what is in the advertisement, that is that should be followed. That is one judgment I have. And about that executive instruction, Deputy Secretary of Women and Child Development Department issues that HON'BLE workers guidelines. Because from 2007 to 2025, there are several changes.
I think you have not understood.
Yes, my lord.
You have not understood.
I will complete. That actually, now the whole selection has not been set aside. The next candidate has been called for giving appointment.
Yes, have you called?
Yes, my lord. That notice is already with me and I have not.
Have you called?
That is not available.
You show us, have you stated anywhere?
No, this is the next last week, my lord. That's why I am making.
Why don't you take out an application and?
Yes, I will take that discuss because I don't want to load the
We can pass an entry order.
Yes, my lord.
Yes, Felix.
But not on your oral submission.
Yes, my lord. My lord, that they have now called the second candidate.
Bring that fact.
And the present opposite party and the second candidate, they are the sister-in-law, and so they are fighting between both these two. Who will join? Either sister-in-law will join or their daughter-in-law will join.
you are the beneficiary of that.
That's why, my lord, the appointment was, they have called the second those in the merit list. Now, the father wants that the daughter-in-law should join. But he is in the fourth in the merit list. Who was present opposite party.
When you can take out an application.
My lord, I will find day after tomorrow. My lord.
But on a proposition, it should be on the 30th.
Right.
So I'm ready on the proposition of.
My lord.
Yes, for the next.
Item 30.
The lordship may protect me. Pardon? Lordship may protect me that no third party. No third party. That's only.
What are you talking about? You have to show that they are taken. Bring those facts.
Because of curfew and all that thing, I could not, my lord.
No, sir, no matter.
Only orally direct.
Last person to
Yes,
pass an entry order on the oral submission.
I know, my lord, that's I lordship, because only lordship may direct the government advocate what's to take.
AIR 1994 Supreme Court, please read which originate from the Calcutta. and how the Supreme Court has dealt with on an oral submissions, orders are passed.
Madam, it takes 2.5 hours from that place to this place.
I know,
We
my
need
lord.
to cut how much time? A person to come.
No, he has given me everything, but due to I am down with fever and the curfew that makes me numb. I just don't want to load the code because of every case.
Not the actual thing. Justify that immediately.
Pardon me to mention, Your Lordship, I pray for a short adjournment on behalf of my senior Mr.
What is this?
This writ appeal, the appellants have challenged the impugned order dated 14/5/2025 under Annex 20 passed by the one single judge of this honorable court. To reinstate the respondent in her service, she was, according to the board meeting, as per the inquiry report, she was punished with compulsory retirement. So,
Punished?
yes, sir, that punishment was granted her that she will be taking a compulsory retirement, and that has been dealt in the writ petition, the disposed of writ petition. And the learned single judge has ordered to reinstate her in service within a period of 2 weeks. We have come in appeal against that.
When your senior will argue?
Any day, Your Lordship, after 16.
Fix the matter on 27.
Item 31.
Thank you.
I'm against the order of single judgment unless one minute. The next one, the learned single judge has the order. Upon hearing from the learned counsel for both the sides, it is felt proper disposal of writ
So
petition.
you wanted to establish your title through a jurisdiction.
My lord, under the Oiler Act, I have already been, there is a proceeding started against me under Oiler Act. So in order to complete the Oiler Act, I have filed mistakes before the Oiler Authority, that is a video officer at HON'BLE. Thereafter come before this court, and the court and first instance has the past order.
No, simply says that you have a remedy, civil remedy, and you go before the civil forum.
Once it is coming under Oiler Act, so in the Oiler Act there is a prohibition, that is under section 67. If anything
Giving
other,
right title by way of adverse possession.
man, 33 years he is in possession. There's already there is a
No. Anyhow. But
there's already the process has been started under Oiler Act. That is in the year 1980 to 83, I am in the possession matter. Basing on which I have filed a miscase before the Lord Tahsildar HON'BLE under Annex 2. While filing this, I approached this honorable court because they have not heard the matter. Then this honorable court has directed the authority to consider the matter. Thereafter, they have passed the order. Then we come before this honorable court. And this honorable court decided that you will go for civil suit. So there is a section 67. Is a bar of jurisdiction of civil court.
I'm asking you, can you seek a remedy on adverse possession before the revenue officer?
We are before the revenue officer regarding.
Is he competent to pass a decree for declaration that you have perfected your title by way of adverse possession? Can he? The bar under section 67 will definitely come, provided the revenue officer has a competence to decide the cause. If he has no competence, then can the bar apply?
My lord, when that Tahsildar has passed the order, he has never stated that he is not competent to pass the order.
I am simply asking you, if you ask for your title by adverse position, can a revenue officer decide it? I do not know. There must be a provision of law here. I do not know about it, but I know the other provisions, there is none. Show us that here the revenue officer is conferred with such right.
There is a decision of this honorable court.
I am asking the section, sir. The decision will come later. Any section of the OLR which confers power on the revenue officer to declare the title by way of adverse position.
Next question.
Any provision, OLR. Yours. He wanted a settlement of that, but he put the London judge's procedure that he wanted to, sorry, yes, he has claiming the right by way of an adverse position, which cannot be decided.
Yes, section 12 of the OLR Act, where it is clearly said that decision of disputes among landlord and rights. Any dispute between the right.
Landlord. Sir, you are claiming title divorce the landlord. If it is a landlord and the riot, I can understand that he is taking, but you are claiming title divorce the landlord. You are not recognizing that he has lost his right or title. I have acquired a title. Then?
Next one. Unbensulates.
Your petition before the revenue officer was under.
Absolutely. It was absolutely misconceived.
Then you are claiming that as adverse.
Yes, in the first week of November. Next.
Item 32. There is not. But here not the appellate challenge the her required transfer, but not single just granting the stay. Admit the writ application, but there is no stay. That is page 61.
What is the order? Transfer?
Transfer below. That is
625. Where is the order?
That is page 29 in paragraph 6 below.
No. Page 19 is the order of 13.6 which you wanted the stay.
Yes, below. That is annexer 3.
This serial number is your
18 below.
18. Just been
coming. Yes,
right.
Yes.
You have been transferred.
Transport Tahsil of Mohana Tahsil Office, Kasinagar.
Distance is around 60 kilometers.
150 kilometers.
Where is the bar?
There is no bar.
So in that event,
Milord, YCS transport Milord, that is in page 29, just plus the page 29, paragraph 6.
The order does not speak of that. It's a simple administrative order of transfer.
Yes, Milord.
No.
No, Milord. After her transfer, Milord, she has approached before this honorable court. And that order I have also annexed, Milord, for the considering the representation, Milord. And a representation also made to the opposite parties, and that is the order at annexer 8, Milord. In paragraph 6, just have a class the paragraph 6 of 29, Milord, page 29. Only the allegation is, I am reading, Lord. The Tahsildar Mohana, in his letter number 3287, dated 2/5/2025, has alleged that the petitioner was joined in Tahsil Office Mohana on 6/1/2025. Since her joining, she is failing to carry out the works and instruction assigned to the head.
she is deliberately fighting and quarreling inside the premises, in presence of the public also, misbehaving to other staffs and disobeying the order of the higher authority. And no explanation is sought for to me, Lord.
We have prelude to the transfer. That's not an allegation. There is no allegation made against you. Simply you have been transferred from one Mohana to the other place. That's all.
But cause is blood.
The cause is not. There was some request which was made, but for the administrative exigencies, if the transfer is there, the matter is pending before the single bench, you go there. It's not a fit case for stay.
But,
you wanted the observation from us?
Yes. Yes.
Rejection of the interim order?
No, Lord.
So,
sorry. Sorry. I will approach there.
So what?
Yes, Lord. Propose.
The single bench has nothing. They simply issued a notice, nothing more than that.
You have handed over charges.
Yeah, charge not have.
You have been relieved.
Not
And you are
relieved.
directed.
Not relieved.
First, then we have to pass an order. If we don't, then you have to.
Well, item
I will
40.
approve there. Right.
Item 53.
Yes.
Well, item 40.
Item 32
Well,
is
item
order to be
40.
made, as per clarification of the admission to the course of nursing. So twice come. Last date is 31st of October.
This matter to continue tomorrow as well.
Well, item 40, the interim order is expiring today. And pleadings are not complete. One more counter has to be filed. You actually may call it in November and interim order to complete. Any date convenient.
All the cases we have filed counter. One is copy has not been solved. I'll solve 430 days.
File a counter.
Yes, counter has been filed.
We are fixing this matter on 27, 28.
Yes, sir. Interim order to continue till then.
The real purpose is this.
No, we will have it here. What you may have it. Any day in the first week of November. Fair enough. Whatever, Lordship.
The same matter where my learned senior is mentioning, it's a batch of matter. My second matter, only a IF amendment is there is a formal amendment, my name. If that is allowed, I will be able to file my rejoinder.
Read Shakespeare's observation. What is there in the name?
Because the office is not accepting my rejoinder.